right, guys, welcome back to another edition of Lawyered Up. I am your host, Jared Moore, and once again, I am not a lawyer. On tonight's program, we have Miss Mary Kathryn Nagle joining us. You may remember her as a Cherokee playwright or also as the legal representation for the MCN and Hickory Ground in MCN versus the Poarch Band. Now, you guys may have remembered our previous coverage on this case. We're just going to do a little update of what's going on right now. But previously, I think it was in December, the 11th Circuit Court of Appeals remanded the case back to the Alabama District Court and ordered that Ms. Nagle and the Hickory Ground file another amended complaint, and then that's going to get heard. And is that all accurate, Ms. Nagle?
Yes. The only thing I will say is that our motion for leave to file the third amended complaint, the court may decide it without a hearing. So in terms of being heard, it'll be considered for sure. We may not have a hearing. The court could ask for a hearing, but it hasn't yet. So my guess is the court will issue its ruling without a hearing. Okay.
Well, and I had some questions about that too, because I was going through and reading the filings. And it seems like, because this is one of the things in your motion that you're pointing out that, yes, we are filing an amended complaint, but it's because the 11th Circuit has said that we should file an amended complaint.
Yes.
Because there's also Poarch Band and University of Auburn have filed their oppositions to the motion to file this complaint, where they're saying this case has gone on too long and all these other things. So I guess the first thing that I wanted to touch on is what are the differences in the new amended complaint that you're asking permission to file? What are going to be the differences in that versus the previous ones that were heard?
I would say by and large, it's vastly the same complaint. The biggest difference is that the 11th Circuit instructed us to separate out our claims so that, for instance, if we have a NAGPRA claim and we also have ARPA claims and we have a claim under the Indian Reorganization Act, the IRA, that we separated out claim by claim so we don't have more than one statute at issue in one claim and not more than one defendant at issue in one claim. So previously, for instance, we had a NAGPRA claim and we just listed all the defendants we had NAGPRA claims against in the same claim. Mm-hmm. And it gets a little complicated when you have a case like ours with multiple defendants, multiple claims, especially if the district court's trying to evaluate what claims it's going to dismiss, what claims are going to stay in the case. And it's much easier for the district court to say, okay, count 12 is gone, count 13 is gone, which is, this statute against this defendant, this statute against that defendant. And kind of grouping them out by the Auburn University defendants, the Poarch tribal official defendants, and then the federal defendants, which are the federal agencies and individual officials that have been sued in this lawsuit. So by kind of breaking those out, it expanded by significantly the pages and the amount of space we needed in this complaint. The other updates, we added facts that have taken place since the last complaint was filed in March of 2020. And so, it's been 5 years, and we updated on different things that have happened since then. For instance, the fact that Poarch engaged in additional construction at the sacred site in 2023 and refused to even share any kind of documentation with Creek Nation or Hickory Ground regarding what kind of surveys or what investigations they performed to ensure that this new construction wouldn't result in further desecration of burial sites or funerary objects or other important cultural resources. Creek Nation was very clear and asked Poarch to not engage in that construction until that investigation could be undertaken, and Poarch refused to do that, which has been somewhat typical with their conduct to date. And so we added some of that information in. And we have a few other, where we had maybe more than one statute at issue and one claim that's been broken out into separate claims. So really, by and large, that's the majority of the changes. And like I said, a lot of what's in there, I guess I should say, we also added some allegations that relate to the affirmative defense that the Poarch Band tribal officials are asserting, which is that they're entitled to sovereign immunity under the Coeur d'Alene's exception to the Ex parte Young doctrine. And we added some allegations that were already in the complaint before, but we kind of expanded them and got a little bit more detailed than what we previously had to address some of the arguments they've been making about sovereign immunity. And so that's by and large the changes.
And if you guys want a discussion of Coeur d'Alene and everything, you can watch the previous covers that we did with Ms. Nagle on a previous Lawyered Up.
Yeah.
And I do want to remind you guys, the motion that we're talking about, there's a link in the description here. You can go read it. Now, I will give you guys a heads up that because it's so long, I couldn't get it all into our Google Docs. So what I had to do is I cut off the exhibits. So the motion is in there, but there's not all of the exhibits that were attached to it, because there's like, it was like I think the whole motion is like 400 or 500 pages. I think it's in the ballpark of it.
And that's because we're required to file our complaint with the motion, as well as all of the exhibits that we attach to the complaint. And so the motion itself is 20 pages or less, I think. But the complaint, the third amended complaint, is about 110 pages around. And then we have a lot of exhibits, and some of them are in the hundreds of pages. So yeah, it's a pretty hefty filing.
I wish I could have put all of that in there too, because I was just going through and reading all of those exhibits, you know, the historical documents and stuff. And I was like, oh man, this is really interesting, but it just wouldn't go in. Google Docs was like, no. So, but jumping forward, let's talk about whether the judge is going to grant this motion. Me as just an outside observer that doesn't know any better, I would assume that if the 11th Circuit remands this case and then orders there to be an amended complaint filed, that the judge is just going to decide that, you know, and you were, as we were talking about earlier, you're saying there's not going to be a hearing about it. You think he's just going to go ahead and approve the motion?
I am very hopeful that is what is going to happen. I think we really did our best to stay within the bounds of the instructions from the 11th Circuit. I think given the complex nature of this case, the number of parties involved, and the fact that the defendant's violations of the federal laws that protect hickory ground are ongoing. They haven't ended, right? So the more years this lawsuit keeps going, the more facts we have to talk about, the more issues there are, the claims continue. And so there's going to be inevitably, every time we file a new complaint, just because the litigation is still ongoing, more pages and more things to talk about. But beyond that, we really followed the 11th Circuit's instructions, and the 11th Circuit told us to do this. The district court told us to follow the 11th Circuit's instructions. Poarch and Auburn are arguing, really, to be fair to them, they haven't challenged the majority of the third amendment complaint. They're only challenging 4 specific new claims. And Auburn is also arguing that it should not have to, if we prevail in this lawsuit, Auburn should not have to pay attorney's fees. And Auburn seems to be very upset that we're now asking them to pay attorney's fees. But that's really the crux of what they're opposing in our motion, is just those 4 claims.
Yeah, you know, I was reading there that Auburn's filing on that too, because they're saying that because they are a state university, they are an entity of the federal government, and so they have immunity from certain of these suits, which I thought was interesting, because it's like, how is the Auburn gonna claim immunity from anything on this when it's directly tied to their activities as a university?
I know, yeah, and really, that's the kind of thing that would really necessitate full motion practice. That really isn't appropriate for a motion for leave. It's really kind of a motion to dismiss stage issue. But of course, Auburn would love for that. They this entire litigation has been going on since 2012, and they're just now raising sovereign immunity issues. But I think they're feeling more and more heat, especially as folks from Creek Nation are raising their voices and demanding justice and saying, what is Auburn doing? Why won't they give us our relatives back? And there's really no excuse for what Auburn's doing. So I think their lawyers are starting to fight back a little bit more, just because there's more public pressure on them. Yeah.
Well, and the other thing too is, at this stage where we're at, let's just assume that the judge grants the motion, the amended complaint is filed. With the experience that we've had in and when I say we, I mean the MCN and Hickory Ground that they've had in the district court already, would you say that the amended complaint would get a fast hearing, we get a fast decision out of all of this? Is there going to be a public hearing on this, kind of like what happened with the appeal and everything?
On the motion for leave, probably not. But probably what will happen is, even if we lose this particular argument, we still get to file a third amendment complaint. It just won't have those 4 claims
I got
that are challenged.
those will just be removed, and then
okay. Again, I can't say for certain what the district court would do, but I imagine the district court would order us to file our third amendment complaint and excise the whatever portions the district court doesn't allow us to include. And once we do that, then the defendants will have probably 60 days, but we may negotiate otherwise, to draft and file their motions to dismiss. And then we would probably have 60 days to respond. And then they might have 30 days for a final reply. And then we would wait for the court to schedule a hearing. I would imagine the court would schedule a hearing just because the motions to dismiss are going to be, again, quite complex with lots of legal issues to decide. And I would think that it would help the court to decide the issues to hear or argument on the motion to dismiss. But we'll see what the court ultimately decides to do.
Okay. The reason I was kind of asking that question too is kind of like, we're not introducing, let's say that the judge grants the motion to file the amended complaint, and whether those 4 exceptions are in or out, there's not going to be a whole bunch of new evidence submitted or anything. You know what I mean? Like in a jury trial, it's basically going to be the same things that have already been presented, only heard on specific individuals on each thing. Is that fair to say? The difference in this, when the judge hears the case this time, if we get to that stage, is just going to be that instead of hearing or making a decision based on groups that the things are filed, it's going to be individuals.
Yeah, I mean, it's the same lawsuit, really. Basically, what the 11th Circuit did was say, hey, what the district court did in dismissing the entire lawsuit based on sovereign immunity and Rule 19 was wrong. And what the district court needs to do is analyze the sovereign immunity of the Poarch tribal officials on a claim-by-claim basis, such that if a claim is brought, for instance, against the federal defendants, but not against any of the Poarch officials, it doesn't matter what claims of sovereign immunity they may claim. The claim's not against them. It's against the federal defendants. So Poarch's claim of sovereign immunity for the claims brought against their officials should only be evaluated under the Coeur d'Alene standard for those specific claims on a claim-by-claim basis. Once that analysis is concluded, then they can see, okay, are the Poarch officials still in the lawsuit? If so, then there's no Rule 19 analysis to even consider. But if they're not, let's say the court finds in their favor, then the court has to do a Rule 19 analysis at that point. And and that's so. What the district court would actually be considering hasn't changed that much in terms of the facts, the allegations, and the legal issues. It would just be the way the district court would go about in doing it, and the way in which we've amended our complaint would facilitate that. It would make it easier for the district court judge to say, okay, this claim is gone, this claim is still here, this claim is gone, in that way. So the case itself has not really changed substantively.
Gotcha. Well, is there anything that we need to update the audience about with this case that we haven't talked about?
Yeah, I would just urge folks to check out Hickory Ground's social media. They're on Facebook, they are on Twitter, and they are on Instagram. And they're posting a lot about Auburn right now. Auburn just denied Miko Thompson's request to repatriate as a lineal descendant under NAGPRA. And they basically told him, hey, unless you can tell us the exact names and the identity of the individuals you claim you're related to, you don't qualify to repatriate these relatives. And of course, the absurdity of that is that, historically Muscogee individuals weren't buried in a white Christian manner. Like there's no headstone, right? So there's no, but they're from Hickory Ground, and Miko George Thompson is the Miko of Hickory Ground today, which means in a Muscogee cultural sense, he is the direct descendant of anyone buried there, and he has the cultural responsibility to ensure that they remain in their final resting place and that their rights are protected and that sanctity of their final resting place isn't disturbed. And, Auburn, I don't think Auburn is very concerned about following federal law or about about getting it right when it comes to respecting Muskogee culture or religion. And, I think we're at a kind of an inflection point where the more folks kind of apply that public pressure to Auburn, maybe they'll change their minds and do the right thing. But it's pretty absurd that they're refusing to repatriate the Muskogee relatives they took from Hickory Ground to Miko Thompson. And yet they are.
I want to, I have some questions about that. So Auburn is saying that Miko Thompson would have to show lineal descent from who?
Well, and that's it. They won't say who, and keep in mind, we don't have any information on who they literally dug up.
Is that
right?
standard practice? I've never heard of that with NAGPRA repatriations. Like,
I don't think it's standard practice. I don't know that Auburn really is familiar with standard practice. I think standard practice is to really respect the Native American kinship system. Like if you go out and illegally, because it's illegal to dig up these people, you can't just go out and dig up Native graves. But if you go out and dig up, Cherokee graves, then you've got to respect Cherokee culture regarding who is the direct descendant and Cherokee religion and Cherokee kinship systems, not white Anglo-Saxon kinship systems. And we have clans. I mean, Cherokees are not too different than Muscogee people. All kinds of cultural systems that aren't relevant and don't exist within the American legal white Christian Judeo system. And Auburn is not respecting that, and they're not adhering to that. And they just told Miko in a very perfunctory way, like, come back to us and tell us the identity of these people. And otherwise we can't repatriate them. Which is really absurd, and I think violates the statute pretty clearly.
Yeah, I don't know if that even works under NAGPRA. Do you know, maybe what they're trying to do is say that, Miko Thompson is not part of the official government or something, so you can't, we're going to treat the NAGPRA claim differently. I don't know. Do you know if the Muscogee Creek Nation, the government part, have they filed a repatriation claim? Or
they did, and they also said, hey, we defer to Miko Thompson. Like, we're filing our claim because we want to make sure it's our job and our duty to make sure our relatives come home. So the buck stops with us. So here we're filing this claim, but we want to make it very clear. Miko Thompson's claim takes precedent. And to the extent that you don't honor his claim, then you need to give these relatives to us, and then we'll just let him exercise his cultural authority here. But we're really doing this to support him and to support the members of Hickory Ground. And Auburn has just been kind of like, and I think they're getting some pressure from Poarch to not repatriate to Miko Thompson. That's my guess. I don't have any facts to substantiate that, but given their conduct thus far, there's really, it's hard to think of any other thing that could possibly explain their just complete refusal to return Miko's relatives to him. It wouldn't hurt anyone except maybe, I guess, since, if Poarch is trying to claim Muscogee Creek Nation's ancestral territory, that would undermine their claim to Creek Nation's territory if a non-Poarch entity were able to repatriate Muscogee relatives. I don't know. It's really crazy.
Yeah, it sounds crazy, and it is crazy, but with that being said,
yeah,
we're kind of at about 20 minutes.
Yes.
Is there anything else you'd like to add before we wrap up?
That's, I think, everything for now. And, I just appreciate your continued attention to this important case. And like I said, I urge people to check out Hickory Ground social media and support Hickory Ground. And, thank you for everyone for your support. It's unbelievable to think that Miko Thompson is still fighting this fight 20 years later, but it continues.
Yeah, and that's a court. It will probably continue on for an unknown amount of time. But I want to thank you guys for tuning in. I appreciate you guys viewing and getting the update. Again, there is links to those filings in the description of this video. And you know what? I think I might go back after the stream is over and put a link to our prior coverage in there, so you guys want to go back and do that discussion about Coeur d'Alene and all of those things. You can go back and catch that. So I don't see any questions. And let me tell you guys what's coming up tomorrow. We in Oklahoma City, we're going to have a live wire with Muscogee soprano. Just blocked on her mind. Jared Chickasaw composer Jared Tate's American Indian Symphony is going to premiere in Oklahoma City this weekend. And we are going to have Dr. Kirsten Kunkel, who is Muscogee soprano, who is also going to be performing there. She's going to come on the program along with, I don't know who else is going to join us, but that's going to be on the program tomorrow evening. So if you want to tune in and ask any questions about that, go for it. And then, or if you want to catch the show, it's going to premiere in Oklahoma City. I believe it's on Saturday, but we'll get you all those dates tomorrow. So if you guys want to tune in for that, go for it. And everybody have a good Friday. And Ms. Nagle, thank you for joining us. And
thank you so much for having me. Mado.
We will see you guys later. Mado, Hadom.
Mado.